will discuss capacity to contract. Capacity to contract. One of the essential requirements of a valid contract is that the parties must be competent to contract. Section 10 of the Act provides all agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Capacity means competency of the parties to enter into a valid contract. Capacity here also means physical as well as mental capacity. Having the capacity to contract means the person entering into the contract has a legal competence. This means they are competent to perform the act. They are agreeing in the contract. Once a person he enters into an agreement, he is bound by his promise. Capacity here means once he is entered into an agreement, he will be bound by his promise. So let us discuss who are competent to contract. Section 11 describes the persons who are competent to contract. According to Section 11, every person is competent to contract who, number one, is the age of majority according to the law which he is subject. According to the law to which he is subject means if a person is subject to Indian law, in that case he will be bound by Indian law. And number two, who is of sound mind. And number three, he who is not disqualified from contracting by any law. Capacity refers to a party's legal ability to enter into a contract. As per the above definition, any or every person is not competent or capable of entering into a contract. The capacity to contract of a person to be dependent on three aspects. Number one, attaining the age of majority. Number two, being of sound mind and not disqualified from entering into a contract by any law that he is subject to. The following are the conditions for a person to enter into contract. When he enters, he must have competency or capacity. So he will be competent. Number one, if he must be a major. Number two, he must be of sound mind. And number three, he must not be disqualified by any other law. The contractual capacity also means that the parties are able to understand that a contract is being formed. Further, the parties must also be able to understand the basic nature of the contract. In short, when the party does not understand the nature and the consequences of an agreement that they have entered into, the law treats that party as lacking the capacity to form a legal binding contract. In short, both the parties to contract must have contractual capacity or competency in order for the agreement to be legally binding. When it comes to entering into legally binding contract, certain persons may be considered to lack the capacity or want of competency to contract. These persons are the persons who are disqualified to enter into contract are number one, minor, number two, unsound person, and third category is others, that the persons who are disqualified from contracting are alien enemy, number two, insolvent, convicts, and number four is married woman, etc. The capacity to contract depends on the age and mental health of a person. This means that some people do not have capacity to contract and are not deemed to have legal competence. This is to protect people who are not legally competent to protect themselves from harming themselves financially or legally. So here law has given protection to the persons who are not competent. That is simply for the protection of the people who are not competent to contract. So let us discuss all these in detail in the next video.